So you were moving your exemption to where Don Grant homestead, his property?
Our property.
Your intention was?
Yes, our property. Yes. Okay. Let me back up. To be frank, I never needed to move anything. I always asked, but you guys blocked it, to reinstate his homestead. I sent over information. I've got more and more information as the day goes by. From the mortgage company, like, this is a mess. We didn't want to start a new homestead. It should have never been removed. My argument is that the proper protocol for removal or any notices where we could have contested it back then was never sent. So my thing is that... So go ahead.
Here's the thing. We know now, yes, because you're going through a divorce or separation or what have you, he shouldn't have sold the property or given it away, or what have you. That shouldn't have happened. But the district doesn't know that. When a deed gets filed, we process it. When it gets filed at the county clerk's office and we receive it, we process it. That's what we're going to do. And when we get another deed for that particular property, we're going to process it again. And then what the confusion started was, all of a sudden we started getting all these affidavits, and we started getting all these things like, hey, you went to court, you had these 3 people that went with you. It was you, someone else, I believe, and Don's name on there. And yes, we probably didn't process that particular thing correctly, but until we got the other documents, we had it. Now we have it correct, back to Don's name. We have it correct. It's just back into Don's name, basically saying, hey, everything's going back to the way it was. He shouldn't have filed these deeds. You went to court. He shouldn't have filed these deeds. We're putting it back into his name, of which we had already done. And then he can get his homestead exemption, his over 65 on that property. As far as, and we'll date it back to how it was. I can talk to the exemption people about that. But as far as your property located, I forget, where did you say your property located at?
Gerald Ford, Manor.
Gerald Ford, maybe. Because you had a homestead over there back in 24, 23. They removed your regular homestead from there. But where do you stay at?
Both of the properties are under my control, okay? So...
Yeah, but
let me finish answering the question, okay? The home has been under repairs. So I'm back and forth at both properties, okay? Don Grant is 78 years old. My driver's license is now at the 5001 Allison Court. We both have gone back and forth due to vacate protocols with the damage to the property. So it's very hard, and that has been exploited, okay? It's been exploited. That's the thing. But before this, there was a divorce filed. Don Grant lived at 5001 Allison Court, had that homestead for 22 years. I lived in Manor. The deeds were separate. That was the point. We're getting a divorce. We're going our separate ways. We're not trying to tear each other apart. That's your homestead. It's my homestead. That's what should have happened. Okay, when all of this stuff happened and I had to go to court to fight to try to save our home that's part of the pending divorce, then our addresses went back and forth with the exemption because of the way that the filings were filed. I had to file a quit claim deed just to protect the property.
Yeah, because he filed a deed, not us. Because he filed a deed.
Which deed did he file?
Started all this.
Wait.
The deed that went to build assets, right?
Okay.
That's what we're talking about,
okay,
right?
Hold on. No, he did not file. Hold on. No, you hold on. Mr. Grant wasn't even here. He was in the hospital. So he did not file any deed to build the asset. Let's get that straight. I've had power of attorney for 4 years. No, he did not. Anything that was filed, it's me. If you have a deed that he filed, it too is fraudulent. He never filed any deeds. I have taken care of everything. So if you have a deed with his name on it, and if you look at that deed, If we're talking about the same one, and I can give you the instrument.
Hello?
I can give you the instrument number. It says Justin Minor. It says Justin Minor. His name signature isn't on it.
Hello?
So, yes, can you hear me?
Okay, it's cutting in and
Okay.
out.
No, he did. If you have a deed with his ID that was checked, that he filed, then I'd like to see it, because that too is part of the problem. He could not, he did not, he would not. Until now, I didn't even have a clue how any of this worked. I can assure you, he did not file a deed.
Yeah. So, like I said, there was a deed filed at the county clerk's office.
Okay.
Which they accepted.
Okay.
All right. And it gets sent to us, and we update it.
Okay.
So we updated the deed to Texas Capital, and then from, like you spoke earlier, you knew it went to Texas Capital, and then Texas Capital went to builder assets.
Okay, but
And then there was
can I before you go, can I stop you there? Originally what you did was you took that deed and it was filed once upon a time, and I have those screenshots too. You had it going from Don Grant to build the asset. You didn't have it going from build the asset to Texas Capital LLC. Technically, build the asset should have never appeared in our deed history, because it wasn't filed that way. Even the deed that you're telling me that allegedly Don filed, which he did not, it always was to build the asset. But you skipped that step and put the ownership into build the asset on June the 7th, when the deed specifically went from Don Grant to Texas Capital LLC. So if anything, and even that's incorrect, but if anything, that's where it should have been. You had it going from Don Grant to Build the Asset LLC. Then it went from Build the Asset LLC back to Don Grant, and then back into Texas Capital LLC. So that's a pretty grave mistake. Even the order of when the deeds were filed, again, if we're talking about the same instruments, is backwards.
Okay. So, where do you reside at?
I need you to answer the question that I answer.
That's what I'm looking at. So, right now in 2023, the property went from Don Grant to Texas Capital, and the same month in 2023, Capital to Builder. Then there was you went to court. There was a judgment of some court that you went to, and basically it was you and Shane that were defendants, and basically we processed that out of builder assets to you two. And I was thinking, well, maybe should we have done that? And then we got another correction quitclaim deed. We got a quitclaim deed from you, filings and quitclaim deeds in 2024. And in 25, we have several quitclaim deeds. And we're trying to get this straightened out. This is why I'm calling, because we're trying to get this straightened out, because we're like, there's a lot of filings and back and forth.
We were trying
that are filing, like release of liens. We don't work off of release of liens.
Okay.
We don't work off of deed of trust.
Right.
And all these documents mention release of liens and deed of trust.
Okay.
Which we don't work.
Okay.
And so we know, well, okay, sounds like it's going all back to Don Grant. Like everything's going back to Don Grant like it used to be.
That was the intent. Okay. And
Okay.
I've had to fight like hell for the standing that the fact that nothing should have been touched, because there was a divorce. And then even when we filed bankruptcy, just trying to get away from this fraudulent scheme over and over and over, no matter what we did, there was somebody somewhere that didn't follow the original recording or whatever the case may be. So I do understand how it could have been confusing, but no one reached out to say, hey, or when I filed in and said, could you hold this account? Or when I filed the notice of fraudulent filings, that should have put a hold on the account, and it should have been referred to the DA's office to look into.
Who did you file that
I filed
notice
it.
of?
I filed it with your office. I filed it with the real property records. They processed it, and it was a notice of fraudulent deed. So I said, okay, you know what? Maybe I need to alert. Then I've called and said, hey, can you put this account on hold? There's a lot going on with it that shouldn't be. I don't know what to do at this point, but it shouldn't have been transferred anywhere. 23, 24, 25, nowhere.
Well, in 23. So here's the thing. In 23, mind you, this was done in 23, right? Of June of 23. We didn't hear anything back until, a couple months later about these other, when you went to court to take builder assets.
Right.
These deeds were already filed. The appraisal district doesn't know anything that is a fraudulent deed or nothing. We don't know anything about that. There's no way we're gonna know that.
Right. And we don't know that, and we don't know that because the mortgage company involved has sent us paperwork saying y'all are good. They filed a relate back. I think you have that rescission. So there may even be documents that y'all didn't get. I don't know which department it's going to, but somebody knew where to send it to. So the entire time you don't hear anything because we've gone to court. The mortgage company has pretended to be on our side, so we think, only to later find, like this year, that the rescission document was the 2007-02-4009, right? So they rescinded it. They reinstated back to me and then processed me for acquired the title in my name, despite the fact that it belongs to Don Grant and despite the fact that there's a marriage petition that's still pending. So none of this stuff should have happened. None of it. So you're hearing it as it.
They did that, right?
Right.
They did that, right?
Right. So you're hearing it as I hear, but I am filing these affidavits: notice of fraudulent filing, notice of missing assignment, notice of this. I'm trying to keep you guys on notice. Corrective deed this, corrective deed that. So somebody has to pay attention. But when I file it, they're going directly to you. And the indexing keeps changing and changing and changing and changing. And none of the corrections that I'm trying to make are actually being viewed as corrections. They just keep changing and changing and changing, but not in the way or the indexing is moving or, and just as well as I do, that matters. That the protections not being on the home, the exemptions, that all matters. It all plays a role into what I've been trying to correct. Not to mention, none of the changes should have been touched because of the divorce and because of the bankruptcy. Those two federal things, right? And because it was a homestead, there was another procedure that should have been followed because it was a 65 and older homestead.
When you went to court, you filed that at the county clerk's office?
Which one?
The paperwork you got from the court, the judgment, and how everything was fraudulent?
Yes, I did. It was titled Notice of Fraudulent Filings. Hang on a second, I'll give you that instrument number. Hold on. And that's another thing. I mean, I hate to say it, but clearly there's some record integrity issues going on. Because in my opinion, when we did reach out, they were like, file the notice of fraudulent filings. It has to automatically go through a procedure. It's supposed to be sent to the DA, and that should hold the account. It should provide something,
Yeah. And what I'm trying to see, is this what I'm trying to get at? I can understand about him getting his exemptions back on, because he has them all the way already for all those years. Except for 26, because, we're working on 26. And so, let's see.
Fraudulent filings.
So they have their exemptions, and I can talk to the exemption department about, reinstating the homestead exemption for 26. Right?
Okay.
That way, but the homesteads Let me see. Let me make sure that homestead has the date of. He's had it since forever. Yeah, he's had it since 2005 and 2013. Yep, take pictures from online. Okay. So he has that for 25, 24, and 23. 26, he doesn't have it yet because we haven't. This is where we're trying to nail everything down. We're trying to nail it all down. But it sounds like your homestead on the other property was removed because we kind of basically asked you, hey, you can't have a property, two homesteads, which is true. But that's why I was asking, where are you residing? Because if you're at the property in Manor, then you should still carry your homestead there, and Don has his homestead over here in Austin.
That is what's supposed to happen. Because of everything, I've had no choice. I've had to remove the homestead when I shouldn't have had. The marriage petition is already there.
Yes.
You guys made us do that, right? And it's caused so many problems. And I explained.
And it's because the way it was filed.
Okay.
And that's what I'm saying. This is why I'm called.
Okay.
Because I'm trying to get this straightened out, because there's so many documents filed, and the way they file them, the way we read them is whenever there's a grantor, we have to insert certain things to make everything work and flow for us. And so when we see a judgment and it has your name on it, we're like, okay, there's something, you have an interest in this property. And then we see another document that says, hey, this is fraudulent. Y'all are going through a separation.
Mm-hmm.
Yes, he did. He owned it before y'all became together.
And get me, and I'm going to stop you. I understand, but there still should have been. I understand the way it looked, but that was the whole thing. It was made to look that way, right? Instead of the protections, it was made to look like, hey, maybe I'm trying to take something without going through the divorce. You know what I mean? So I completely understand it. Like, you're not the first stop. I've had to fix Social Security. I've had to fix medical records. I've had to fix, I don't even know where to begin. Okay. So I get the narrative driven. I do. I really do. However, I think that prior to now, I've come in and said, hey, y'all, please, it's not me. Take a look at this. Until this is adjudicated, not at JP court, but the divorce court, what you guys are doing is wrong. And then we even took drastic measures and tried to file bankruptcy to get stays to just say, hey, just give us time to breathe so we can try to do what we're legally supposed to do. And we weren't even afforded that. So that notice, let me give you that notice of fraudulent filings is 2025-09-1286.
And that has the court papers in there?
It does. It has the court papers. It has, at the time, there was a pending motion for summary judgment. I'm like, how are you going to get a motion for summary judgment on a house that's owned by a mortgage company? So I put in there who was driving the filings, who was responsible.
Yes, ma'am. So what did the judge, what did he rule on?
Nothing has been ruled on. They snuck through and got a motion for summary judgment on a hearing that we never attended. So all of this has led to even more. So there's I
get it. Here's the thing. I just want you to know. Here's the thing. You might not, I don't know. I'm really trying to help you. Okay. That's what I'm trying to really do and understand it. So one of the things is that what I tell my team is that when we get documents from court or anything, anybody files anything from court, it has to have a judge's signature. Has to. Because we need to know what's going on, especially when we have all kinds of documents filed. I'm giving you an example, not yours.
Mm-hmm.
Giving you an example. There was 2 wills filed. 2 wills. The daughter kept coming in and saying, hey, post this. We kept saying, no, we can't. They go, no, this is a judgment. I have the court papers here.
Mm-hmm.
But we had the court paper, a judgment from the mother,
mm-hmm.
and it had a judge's signature. And there was two decision. There was one decision, and we had to go with that one because that was the judge's signature. That was his, and the property went to the mother. When the mother passes, then the property goes to the daughter. But we had that case, and this is why I told my team we have to have a judge's signature because people can say this. Are there fraudulent deeds filed in Travis County? Yes, they are. And people go to court, and we get those. And once we get those judgments, we update it. And guess what we do? We'll remove all that stuff in history because it shouldn't have even been there to begin with. It wouldn't have been in Louis Esteban's name at all. So we'll remove it. So this is why I was saying, if you did go to court and I see the paper, I pulled it up, I'm looking at it, I'm going through here, I haven't read it all, but I went straight to the judge's signature. I don't see a judge's signature. It's missing. So that's why I was asking, where's the judge's signature at? Because I need it.
So there's been so much. Which paper? I don't even know what you're looking at. I don't even know what all has been filed. Which one does not have it?
That instrument that you gave me.
Okay.
That instrument that you just gave me. It has. I pulled it up online. It's on the clerk's office. Clerk's office website.
Okay.
And so on page 12, 11, it says we're builder assets, and it's yourself, Shane. Who is Shane? Or Beryl?
Sean Ballou.
Sean? Yeah, Bella.
Okay.
And it has Don Grant on there. It has three of y'all that y'all going to court and you're taking build the assets. Y'all taking them to court. And basically you're talking about in here, I'm looking real quick, that the 2023 deeds were conveyed, title shouldn't have been. Some quick claim deeds were filed. I don't see a judge's signature. I get it, but I know what you're trying to do. Y'all give the legal description, and there's some stuff that kind of basically says that you both. Well, I don't know what that is. See, it is further adjudicated and decree that Don and Jacqueline have no legal or equitable interest in the property. Okay, see, that throws me off right there.
Well, so
page 14.
Right. Okay, so here's the thing. They did get a signed judgment, and it's completely fraudulent, right? We didn't go to court. Myself wasn't there. Don wasn't there. And this judgment asked for possession of the property. It has a wrong address. So the reason I'm just floored, and they're going off of the fact that they're relying on the changed ownership and the indexing, because that's all they have. That's all they have. But yeah, he wanted that order saying that we have no interest in the property, awarded himself the property, changed the orders after a court hearing, went to court by himself, and this has continued. This is recent. So this is why I'm you guys are causing us so much damages. If things, the checks and balances would have been done there, it would have been, and I filed that before they got the order saying, hey, this is what they're trying to do. This is fraud. It should have never been. There's a divorce. Now, all this has happened, and there's still an open and pending divorce case right there in Travis County. Same court.
Hey, I get it. I've been through that. Trust me, I've been through the same thing you have where you can't sell property when we're this. I get it. When I read it, I was like, ooh, man, it sounds, it hits home. I get it, because you're not supposed to.
Right. So there should have been a hold, and I understand that you did. I let you guys know when I knew. A lot of this was folding in the background, and I didn't know it.
So here's the thing. I have to, on our system, keep these 2023 deeds on there that say Capital Texas and then Capital to Builder. But what I'm going to do is I'm going to adjust these other affidavits that have been filed, quick claim deeds, these correction deeds, and I'm going to look at the one where we did put where it says has just Don Grant back on there and see should that one stay on there, right? Because I don't see, now that you gave me this one, I don't see the judge's signature. I get your filing all this and saying that it's fraudulent, but for us, and we've already spoken with legal because we literally have fraudulent deeds filed in Travis County. They're all over Texas, but in Travis County, and our attorney said it has to go through court, and the court has to say who gets the property. Even though, the innocent homeowner now has to pay money to go to court and put this property back onto their name, even though they already own it. That's the sad world we live in nowadays. But that has to happen, right? But leave it in Don Grant's name, get his exemption back on there, get your exemption back on to your property, but you have to update your driver's license. I can try to work with that as best as I can and get that going. But all this these instruments, but I have to, once they get filed at the clerk's office, I have to put them into our system somehow, because we have to look at them. I have to identify hey, this was in here for some reason. They filed this instrument. They filed an affidavit. They filed a correction deed on this property. And what are they correcting? What are they correcting?
So most of the correction deeds were filed by me. Mm-hmm. As far as I know, I can't say. I don't even know anymore.
No, that's what I'm seeing.
Oh, okay. So my whole intent was to correct from the bill the asset and to correct the indexing, because with them being in there, they're still showing up as owners even for a short amount of time in 2023 based on those deeds.
Yeah, so that's what I'm trying to tell you. The Texas Capital and Builders Asset deeds I cannot remove from our system. By no means can I remove them until I get a court order signed by the judge saying these two deeds that were filed in 23 were fraudulent.
Okay.
Once I get that, I can remove them.
Okay. So here's what I'm going to do.
I can, and that's what I'm saying.
Okay.
So in history, meaning in the index and history that you're going to see, you'll still see that. But in the years, we already have his name out there. We already have the exemptions out there. In 24 and 25, I can make it to where it has his name on there for those years.
Okay.
Those record years that you can see on our website.
Okay.
I can have it to where it just shows his name. That way you can file for your homestead back on your property in Maynard.
Okay. And what I'll do is I will work on, because Texas also has they have a new rule now, a new law, where I can go and ask the judge to rule on those other two instruments without a full-blown instrument. So I will work on getting an emergency hearing, to get a judge's signature, hopefully, to remove those two instruments from the history that would uncloud the title.
Okay. And once we do that, we'll ask our attorneys to go in there and grab those files.
Okay, perfect. Now, I may have to ask for, and I'll work on getting that. I'll do everything by the book. I may have to ask for a subpoena to get this history, and the audit trail. So I'm still needing that audit trail, even though we're verbally saying that there's some things that we can do to correct it, because that audit trail would also help me secure, when it was filed, how it was filed, and, get a certified audit trail that I can take to court to ask to the judge to look at those two instruments.
Okay. Sounds good. So what I'll do is I will put Don Grant's name in the history for 25 and 24, so you can file your homestead exemption. But like I said, you're going to have to get your license updated to the Maynard address. Okay,
we can do that. And you already have through the Just Appraised, you already have a 2026 ID and application for Don on file. But like I said, we've always asked to just reinstate it, because it should not have been removed.
No, yeah, and it has for 25. It was. The 26, it's off again because we made some updates. Mm-hmm. So it automatically came off. Mm-hmm. So we'll get that reinstated. I'll let them know. Now I'm speaking on behalf. Well, let me not speak on behalf of the exemptions department because it's a whole different department. I'm going to let them know what needs to happen. If they have any questions, I'm sure you'll hear from them on your property in Manor. Okay?
Okay.
I'm going to talk to them about Don and how this stuff needs to go back in there and what they need to see on this system that I'm going to update to show Don. And we'll go from there.
I do have one last question.
Okay.
On the system and the update, my question is you have a deed that is not between Don. That one deed ending in 5471 is directly to Build the Asset and Texas Capital LLC. So why is that one going to go ahead?
Go ahead.
So my question.
No, I said
yeah,
because I was looking at it.
Yeah, Don Grant is not. So my argument has always been, why was that deed ever in our deed history? Because it clearly has two separate parties that does not involve Don Grant.
So here's the thing. When Don Grant. So okay, let's throw everybody's name out of the way.
Okay.
Let's talk about you and I.
Okay.
Just you and I. All right. I'm gonna buy the property from you.
Okay.
Okay. I'm buying your property there in Manor. I'm buying your house. Boom, boom. You sell it to me. We'll go through the title company. Boom. It's in my name. I can, in a month or the next day or that very same day, I can turn around and sell it to someone else.
You have to take title first.
And
you have to take title first. It's called Nemo that. You have to wait. No. You have to wait. You can't transfer what you do not own. You cannot convey what you do not own. This man did not own that property 3 hours later. It's impossible. So the procedure and the law states that yes, you can, but it's like selling a car, right? I'm a notary myself, okay? So many people have lost their cars because they'll go buy the car from their buddy and they'll drive it and something happens to it and they can't go get it out the pound. Why? Because they didn't transfer the property, they didn't get the title, and they might have paid for it, right? But they didn't go and to DMV and put the car in their name first before they either got it impounded or before they sold it to their buddy. It's called a straw transfer. You cannot transfer what you do not own. So you're absolutely right. They can do all that, but they were supposed to wait the 2 weeks, right? Before or after, however long it took you guys to put the title in their name. And then they were supposed to sell it to Build the Asset. It can't go the other way around, and it doesn't change when it comes to us. So in 3 hours, the guy that signed it, Justin Minor, could not have owned the property in 3 hours. Your office was supposed to process the title first in their name and then transfer it. And it doesn't happen in 3 hours. It's taken me months to get paperwork that you guys had. So the names on that deed are forged and fraudulent. It says Justin Minor, acting manager for Texas Capital LLC. That's fraud. Even though Don Grant's name is on that title and that deed, his signature is not on that instrument ending in 5471. So you're right. They can do whatever, but they got to take the title first. They have to take the title first. Then I think I've sent you something where the Secretary of State has ruled that the other deed, 525, is invalid. So if the first deed, the upstream deed, complies with the downstream deed, which is the deed that you're saying you can't remove, and that's fraud. There's no signature on it. Don has to sign that deed. His signature isn't on it, and because of the divorce, my signature isn't on it either, and that was required as well. So Don, he couldn't have signed it without me.
So, I'm looking at the deed that went to Texas Capital first. I'm looking at that, and you know, it has a signature there. Whether it's Don's or not, I don't know. Right? I don't know. But there is the signature.
It says acting manager, and we have since said over and over again, and I can send you another affidavit, we did not authorize any signature at all. It's not Don Grant's signature. We didn't authorize it. An agent, and he says he is the acting manager. Well, guess what? He's the broker. He's the broker. He can't sign that deed, sir. He's the broker. If you want the information in his license number, I can give it to you. He is the broker, or was at the time. He has got a broker's license. I can send you that too. Justin Minor is the broker for Spartan Title.
Yes. So here's the thing. Like I said, when the deeds get filed at the clerk's office, they file them at the clerk's office. They send them over to us. We get deeds and we'll transfer them.
You can't transfer a deed that doesn't have a proper signature and that was not properly conveyed. So before it transferred, it was supposed to go into either Justin Minor's name or was the first supposed to go into Texas Capital LLC's name. You guys are processing a conveyance, and the conveyance alone is questionable because the title did not go directly like it should have from Don Grant to Texas Capital first before you guys put the home into Build the Assets name. It was the same day. Both of those deeds are filed the same day. That's improper. They came over the same day, within hours. You can't convey a title. Now we've got this expeditious process going on, but it doesn't happen for anybody else. Within 3 hours, Texas Capital never appeared in the chain of title prior to the switch on the same day. That's fraud.
Not sure what to tell you there, because I hear what you're saying. Went through a title company, it has a Spartan title GF number on there. Don't know who that is. The very first deed that came through, the Texas Capital has Don's signature, then Texas Capital sold it to Builder. I have to have those two deeds on there. Like I said, when you go to court and you get these expunged, or basically said that those are fraudulent deeds.
Okay.
And he signs for them, I'll remove them.
Okay. But I'm still, I appreciate that much. That helps. But we still have an issue as to how the property still transferred on June the 7th, right? Without ever first going into Texas Capital LLC, right? So Texas Capital LLC never appears to be the owner before you guys transferred it. So we skipped a whole chain of title. You went directly to.
We didn't skip it. We have on our history, we have Texas Capital, and then Texas Capital going selling to Builder Assets.
What date do you have that on both on the 18th?
Correct. Both on the 6th. Well, I don't know if it's the 18th.
Oh my God.
We received it. They were filed on May 17th. Both of them were filed on May 17th, and we worked one of them first, which is, of course, the one that Don owned. Mm-hmm. And he sold it to Capital. And then we processed the one after that, which was Capital to Builder Assets.
On the same day?
More likely, yes. On the same day.
On the same day. Okay. So do you have so let me ask you this. Oh, gotcha. Okay. So you then have a title that we can get that shows that Build the Asset owned it at the time that you guys sent it to Build the Asset? Texas Capital LLC. Do you have a valid title that went to Texas Capital?
From yes, it's that one that it's on the clerk's website. It's 2023.
Mm-hmm.
I'll give you that instrument number.
No, so you're talking about the deed that's challenged, right? That's what you guys used, was the deed?
Correct.
Okay,
yeah.
So the only thing that you guys used for that transfer was the same day deed, correct?
The one that went to Capital, Texas Capital.
Mm-hmm.
We used that 2023 deed,
mm-hmm.
2023-05-4525.
Okay.
That instrument number.
So you use that.
Okay.
That
goes to Texas Capital.
Okay, so you use Don Grant to Texas Capital, right?
Correct.
Okay, and then now the system says from Texas Capital to Build Asset?
Correct.
Okay, so tell me again, how does that deed make sense according to, maybe we need to reach out again to the law department. How is it possible for a deed that's supposed to belong to the property of 5001 Allison Court, Austin, Texas 78744, Lot 21, Block A, Michael Adden, how is it possible for any deed to go directly to build the asset that's supposed to be in Don Grant's name?
It went from Don Grant sold it to Capital.
Okay.
And Capital sold it to Builder Asset.
Okay.
Within the same day.
In the same day. Okay. So
here's the thing.
Okay.
We see deeds like this to Continental as well, through other builders.
But shouldn't it have been accompanied? Right. So, but shouldn't it have at least been accompanied by an authorization form saying, "Hey, I give Justin Minor authorization," because he signs as the owner. Even though he put general manager, he signs where Don Grant should have signed. So he should have at least had a power of attorney. He should have at least had a power of attorney. Go ahead.
Don Grant no longer had interest in the property when he gave it to Texas Capital.
Okay, so but here's the problem.
Once Texas Capital has it, they can do whatever they want.
Right, but here is the problem. Here's the problem. Here's the problem. He has to sign it. And here's another problem. Because of
Don signed it.
He did not sign it, sir. He did not.
He signed it from when he gave it to Capital?
No.
Texas Capital?
No. That's what I'm trying to tell you.
That's not his signature?
No. That's what I'm trying. No. What Don signed was a HUD statement, right? I've got the closing packet. Mm-hmm. That those deeds were not in there. That's why you have two dates. You have one that says the 17th.
So did you that instrument number that I gave you at the clerk's office? If you pull it up on their website, you will pull it up and you will see the deed that has his name on there as the grantor,
right,
and has the grantee as Texas Capital, and has the date.
Gotcha. Okay. Are you pulling that up? Listen. Are you looking at that right now?
Mm-hmm.
Okay. So I have since sent you guys a fraudulent investigation from Secretary of State. That is not Don Grant's signature, right? And if you look at the bottom of it, it says Sylvia Inez Sprout. I know you're not a forensic anything, right? But if you look at it, do you see that the notary strikes through the date of birth? Do you see that the signature on that deed is Sylvia Inez Sprout? And that the signature of Don Grant is above the notarial certificate? Do you see that now? That's what I'm trying to explain. These are two deeds that were filed into the records. The Secretary of State have since said you failed to maintain the records of the notarial certificate. But even on that deed, it is signed as Sylvia Inez Sprout. Even that deed is fraudulent. Now, do you understand what I'm trying to explain?
So when you go to court and get these done, we'll wipe them out.
Right, but you're not listening to the evidence that even you have. You told me that Don signed them, right? And
yep, it has his name on there.
No, it does not. It has the notary.
I see a notary.
And it says sign, and it says signed before me, Sylvia Inez Sprout, right? Okay, and it says ID, and there's a strike through the ID, and the signature is a copy and paste. Where I don't know if it's that one or the second one. The clerk says, "Hey, this was recorded the same way. It's not legible." Blah 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 blah. The signature, and I know you see this every day, and you're one of the managers, so I know you know this, is above the notarial certificate, not in the block. I should not have to go to court because the Secretary of State have already said that it's not properly notarized. And I've sent you guys that information. I shouldn't need an order when it shouldn't have been filed with the notary's name right there on top. It says signed before me, Sylvia Inez Sprout. Then it says date. Then it says ID, and there's a strike through. Excuse my language. There's no way in hell that should have been filed. It doesn't match the signature, and it's a copy and paste signature. It's not a wax signature for Don Grant. It's a copy and paste from his other deed instruments that he did sign back in 2005. That's the same signature, and it's a copy and paste, and it is nowhere in the notarial block as it should be. My granddaughter could make a better call than that. It's not there. He didn't sign either one of the deeds. Louis, it's not there. They're visually defective.
Okay. I will take this up to, I will discuss this with my team, and like I said, because they went to court too, right? Builder Square or Builder Asset, and the judge hasn't made a decision yet.
The judge,
right? You're going to court,
right? But the judges, the information that they're using, Louis, are the same deeds that you guys are indexing. So it's very imperative.
But if it was fraudulent, so here's the thing.
Okay.
Remember when I said that we do get fraudulent deeds here?
Okay.
They're notarized and all that stuff, right?
Mm-hmm.
They're in our system.
Okay.
They're posted in our system.
Okay.
They go to court, and the court rules, yes, this property still belongs to say it was fraudulent deeds filed, and we remove them. That happens. So we still have the fraudulent owner on the system, because right now we don't know it's a fraudulent owner. And I'm not talking about your property. I'm talking about another property.
Right.
Other property.
Okay.
They're in their names.
Okay.
Until those homeowners go to court, and they do go to court, because we don't even have their names no longer on there. We've had at least 10 of them already, and we get them back on their name because they went to court.
Trust me, we're going to court, and like I said, the affidavit, a certified audit trail will help me file, and I can get that review without much more problems. You know what I mean? So if you'll correct what you can, give me the audit trail, take it back to your team to see if that's just going to be necessary, especially with the signatures and the default signatures. I can send you over the Secretary of State. It's already gone through an administrative side of things. And I thought you guys had that. It should have been in the packet with the complaint saying, hey, the Secretary of State has already said it. I shouldn't have to go back to court. But I am going to do that judicial review, because it is something that the law has changed. And, if I've got the certified information, then it is a decision that hopefully is not much more of a bigger, burden. But Don Grant did not sign that affidavit or that deed either. So even the one that you're saying, I got to keep it on the system, it shouldn't be there. It wasn't, the proper protocol wasn't filed. The notary wasn't filed. I have information. I've gone through the Secretary of State. It's not correct. I can send you that information so that you could take to your team to make a decision. Meanwhile, if you'll give me a certified audit trail of the IDs and the changes, I think I can take it from there and, basically explain that.
You already did an open records request?
I did. Yep.
Okay.
Yep.
That's how you'll get the information from us.
Yep, I did. Asking for the audit trail, the history, the changes. I should be hearing something. I just hadn't heard. I wanted the microfilm, but and it's no secret. I mean, you're not saying it didn't happen. You're just saying that you went by what you had at the time. So, I did that open records request. So if I could get that, I'll get everything scheduled, and then we'll just go from there. But you should see Secretary of State conclusion of those instruments that we just spoke of, the deed of trust and those deeds in particular.
And you filed that?
It should have been in the paperwork that you had.
Okay. And remember, we don't work off a deed of trust or release of lien.
Right.
We don't.
Okay.
We don't. Pay no attention to those.
Okay. So then we'll just I'll just focus on those other two instruments. But yeah, if you could go back and see, what can be done.
Look at this instrument that you gave me with the that has the court affidavit on there.
Mm-hmm.
Where you went are in the process of court.
Right.
I wish there was a signature, but there isn't. So at least I'm looking to see what's filed and what the intentions are and what's going on here.
Okay. So check that out, and like I said, I'll get that other review because without everything else, I'm supposed to be able to go get it filed and just get the judge to make a decision whether to remove them or not. With the audit trail and the discrepancy, especially from the Secretary of State, it should be, able to be done so we can get them removed.
Sounds good.
And if you want, if you need those, if you don't have them, which they should be, I filed affidavits, and the Secretary of State filing was one of the things that should have been at the first of the complaint, saying, hey, it's already been reviewed. The notarial certificate was flawed to begin with, so we can't count that as a signature from Don Grant. We can't. Not with the notary's signature being in the same block.
Okay.
So let me know.
What did the county clerks tell you?
As far as what? Well, the county clerk, I'm filing to get it removed, but I need that audit trail, and I need as many corrections.
Yeah, but the county. Here's the thing. Here's the thing about the county clerk's office. The thing about the county clerk's office. They're not waiting for nothing from us.
Okay.
Because we go off of
it's the other way around. Okay.
Whatever information they give us.
Okay.
That's what we do.
Okay. So
they're not waiting for us.
So initially the filings were at the county clerk, and then you guys followed up from their filings. Because I've done open records with both, just so I can try to get everything. I've done. So
whatever you file over there, we try to get over here, so we can do what we need to. And that's what I'm saying. There's a lot of filings that we see, affidavits that have been filed by you. And we're trying to figure out what is the intent here. But it sounds like the intent is everything going back the way it was. You get your homestead, he gets his homestead. And but what I can't do is, Texas Capital and Builder Assets should not even be on the system anywhere because there was a fraudulent. But I can't do anything about that until I get a court order.
Okay.
Or, as you're saying, something else. But
okay.
We'll look at it. Okay.
The other thing is that this is why it makes sense. You say you can't do anything with the deed of trust, but that 2007-02-4009, it or the rescission, when the mortgage company was trying to correct a lot of this, it went back to that 2007-02-4009, which is a fraudulent deed of trust, right? Instead of the original deed. So the original deed was way back in 2004, I believe, or 2005. So that's a huge discrepancy too. I understand that it moved in different lanes, but what was allegedly reinstated, the original deed, would be Don Grant's 2004. So it's going to be two. It's either going to go back, it's either going to relate back to the last valid deed, which was the 2004, or the quitclaim deed. So that's imperative too, because you still have to figure out which deed is going to be the last valid deed of conveyance.
Well, once we get that from you also.
Okay.
On your part.
Okay, because I think you have that as an affidavit, as one of the correction affidavits. You may even have it in a corrective deed saying, hey, the last deed should be the 2004 quitclaim deed, especially since we're still married. Right now today, there's no final divorce decree.
No. Yeah, I get it.
So, yeah, got some fixing to do, but hopefully it can stop being a nightmare for all of us. That's my prayer. So do what you can. I look forward to hearing from you. I did the open records request.
Okay.
I'll get the filing so we can see about those other instruments and let the judge decide. But I'm convinced that if the records are fixed on y'all's end and I get those certified records, it shouldn't be a problem, especially since he's had the homestead for 22 years, especially since the divorce is still pending.
Okay.
All right.
Sounds good.
All right. We'll talk to you soon.
Thank you.
All right. Bye-bye.
Bye-bye.